Today on the program, we look at justice delays, the causes, the nature of frivolous cases, and the norm. We have the views of Dr. Babatunde Ajibade, a senior advocate of Nigeria and managing partner of SPA Ajibade & Co. Also, highlights of the 2018-2019 Federal High Court legal year as Anambra State inaugurates State Judicial Council members. Plus, our question of the week: what obtains in Nigeria? Do the Nigeria police arrest before investigating, or vice versa, investigate before arrest? The reality. Hello and welcome to this episode of Law Weekly. I'm Millicent Walker. A common question every client asks is, how long will this case take before it's finally over? Lawsuits usually revolve around some significant event in a person's life, usually an accident or an injury or other event. Thinking about them alone can be stressful and sometimes feel like they are consuming every moment of your time. But solace comes when you have a lawyer to handle things. But to what extent? Why should it take a long time to get justice, for instance, in Africa, compared to the developed world? My guest today believes that the system is to blame for the case delays and says that litigation is like a tripod, needing all the parties, the litigant, the lawyer, and the judge to advance. What are the mindsets within the judiciary that allows the culture of delay to fester?
I don't think the problem is the problem of the judiciary. I think the problem is the problem of our entire legal architecture. That's a phrase I've used repeatedly when I've written about this. So it involves the judiciary, it involves the lawyers, it involves the administration of the courts, it involves several factors, and until we address all those factors holistically, it's not a problem that's going to go away.
Have you witnessed situations where a case is taken to court, to be decided upon, and the judge delays hearing, or the judge is not there to deliver hearing? Yes,
it happens often. And that is the aspect that concerns the judiciary. Too often you go to court and the court is not sitting for no discernible cause. Apart from the fact that it's disheartening for litigants, it's also very disheartening for lawyers, because a lawyer that's worth his salt actually makes a lot of effort to prepare for court. So if you prepare today to go to court and you're there, worse still, you're there for a few hours before you're told, oh, the judge is not sitting. That's time wasted that you can't really claw back. So it's not good enough. But, and I'm not making a case for the judiciary, but I do think that there are factors that contribute to this. I think the judiciary is under-resourced. And I think our judges are, in most cases, overburdened. And I think that is part of what leads to, lawyers turning up in court and you're told the court is not sitting. If a judge has, in busy jurisdictions like Lagos, on a bad day you have 30, 40 cases on your docket, it is practically impossible for any judge to deal with those cases efficiently. And what I see, what happens, why the judges sometimes just decide, what, I'm not going to sit today, because they're overwhelmed. They're overwhelmed with the amount of work that they're expected to go through in the course of a day, and they just decide, I can't handle this. And that just leads to the backlog keeps increasing. The current Chief Judge of Lagos State is trying her best. She came in with an attempt to clear the backlog, but it's a mountain. It needs more than just that effort to solve the problem.
The characteristics of a good lawyer: questionable motions, several objections, and adjourned dates.
I mean, we all know what these tricks are. It's not so much the trick; it's the structure of our system that is at fault. I'll give you an example. The Federal High Court was established in 1975, and it derogated from the jurisdiction of the state high courts. The state high courts at the time had unlimited jurisdiction, so the Federal High Court took a little bit of that. And the jurisdiction of the Federal High Court has been expanded over time. Now, we've been having cases debating whether, a matter should be in the State High Court or the Federal High Court ever since the Federal High Court was established in 1976. And we're still having those cases today. Every litigant will tell you, every good litigation lawyer will tell you that one of the fail-safe methods of delaying a case is to challenge the jurisdiction of the court. So if the action is commenced in the State High Court, you find some reason to contest that court's jurisdiction on the basis that it should have been in the Federal High Court, and vice versa. So if it was in the Federal High Court, you say it should have been in the State High Court. Now, because our jurisprudence also says that once you challenge the jurisdiction of the court, it is a matter of prime importance. So whichever way the court rules, immediately you have a right of appeal, because it's a point of law, and that right of appeal is automatic. Also, there's jurisprudence to the effect that once there's an appeal on a jurisdictional point, the proceedings should be stayed until that jurisdictional point is determined. So you have the potential, with just that loophole in our system, that a litigant who has a bad case will raise a jurisdictional objection, which in a system that has about 30 cases per day, will take maybe the court of first instance 3 years to determine, and then it goes on appeal for maybe another 4 years, and then it goes to the Supreme Court for maybe 6 years. You've had cases in which the Supreme Court has, after 13, 14 years, been asked to determine whether this case should have been in the State High Court or the Federal High Court. So the substance of the dispute has not been touched at all in 14 years of litigation. You spent 14 years litigating about where to litigate.
And the judges can't do anything.
Unfortunately, that's what I'm saying. It is not in their power because that is our jurisprudence. So we need to take a holistic look at all this and change that system. I've written papers about this. I spoke at the Ministry of Justice in Lagos State about this many years ago and said it's a constitutional problem because the right of appeal in our constitution is pretty lax and open. Once you raise a point of law, which a